The 5-year rule allows the government to take your home, and most older adults do not discover it until it is far too late to fix anything. If you are 65 or older, if you own a house, if you have any savings whatsoever, you must understand exactly how this rule operates, because the people who should be explaining it have a powerful incentive to remain silent. There is one particular document that can stop this entire chain of events before it even starts. But most estate lawyers will not mention it unless you specifically request it by name. I will tell you exactly what that document is called before this video ends. The rule is known as the Medicaid 5-year look-back, but that label is misleading. It is not really about reviewing your past. It is about penalizing you for actions you took when you had no idea you were doing anything wrong. Here is how it works. If you ever require long-term nursing home care, and the average stay in this country now costs over $18,000 per year, you will almost certainly exhaust your savings. Therefore, you will need to apply for Medicaid to pay the bill. But before Medicaid pays even $1, a state caseworker will examine every bank statement, every property record, and every gift you made during the previous 60 months. Every single transfer, every check to a grandchild, every car title you signed over, every dollar you moved. Then they calculate a penalty. The penalty is not a simple fine, it is something worse. The state adds up everything you transferred during those 60 months and divides it by what is called the regional penalty divisor, which in most states ranges between $10,000 and $12,000. The result equals the number of months you are disqualified from Medicaid coverage. During those months, you must pay for the nursing home out of pocket at more than $9,000 per month, even though the reason you applied for Medicaid is because you do not have $9,000 per month. This is the trap. You gave away the money, so you cannot pay. But because you gave it away, the state will not pay either. So who pays the facility? The nursing home does not care. They will sue, and the first asset they will target is your house. Most people assume this rule only affects large transfers. That is incorrect. The look-back reviews everything. A $400 holiday check to your granddaughter counts. Paying for your son's wedding counts. Helping a grandchild with tuition counts. Canceling a loan to a family member counts. Selling your car to your nephew for $1 counts. Even charitable donations above a certain limit may count depending on your state. There is no birthday exception. There is no holiday exception. There is no I did not know exception. The federal annual gift tax exclusion, which currently sits at $19,000 per person, has nothing to do with this. That is an IRS rule. Medicaid is a completely different system with its own standards, and Medicaid does not care what the IRS allows. A gift that is perfectly legal under federal tax law can still trigger a full Medicaid penalty. Most seniors do not understand that difference. Therefore, they assume their gifts are protected. They are not. Now here is where it becomes even worse, and this is the part that tears families apart after someone passes away. If you are married and your spouse enters a nursing home, you might believe the law shields the healthy spouse who remains at home. There is a safeguard. It is called the Community Spouse Resource Allowance, and in 2026, it is set at $157,920. That is the maximum amount of countable assets the at-home spouse may keep. Everything above that figure must be spent down before Medicaid will contribute a single dollar. $157,000 sounds substantial until you realize what it must cover. Property taxes, home repairs, Medicare premiums, groceries, fuel, prescriptions, emergencies for the rest of the healthy spouse's life, which could be 20 years. That works out to roughly $657 per month. That is the amount the state expects you to live on while your husband or wife stays in a facility charging over $9,000 per month during the same period. But the house, surely the house is protected. The home is the one asset they cannot reach. That is what nearly every senior in America believes, and it is incorrect. The home is exempt while you are alive and residing in it. Therefore, Medicaid will not force a sale before you qualify. But the moment the Medicaid recipient dies, a program called the Medicaid Estate Recovery Program begins. Federal law requires every state to attempt recovery of care costs from the estate of any Medicaid beneficiary who was over 55 when benefits were provided. The primary target is the house. The state files a claim against the estate. The heirs are told they must either pay the full amount, often hundreds of thousands of dollars, or sell the property and hand over the proceeds. The average estate recovery claim in this country now exceeds $74,000. In some states, it surpasses $200,000, and it is not optional. It is not negotiable. Federal law obligates the state to pursue the home. Therefore, the house your parents intended for the grandchildren can end up going to the state instead. And in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, there are additional statutes called filial responsibility laws. These laws state that adult children can be held financially liable for unpaid nursing home bills of their parents. For decades, these laws were rarely enforced, but beginning in 2012, after a Pennsylvania appellate court allowed a nursing home to collect $93,000 from an adult son for his mother's care, enforcement increased. Therefore, the danger is not only that the state claims your house. The danger is that after the state completes recovery, the nursing home can sue your children for any remaining balance. Here is a real example. A widow in Ohio, age 78, transferred $45,000 to her daughter over 4 years. Birthday gifts, holiday checks, assistance with car repairs, nothing she considered extraordinary. She entered a nursing facility in month 47 of that 4-year period. The state divided her $45,000 by Ohio's penalty divisor of $7,463 per month and disqualified her from Medicaid for 6 months. The nursing home billed her $9,200 per month for those 6 months. The total bill was $55,200. She did not have it. The facility placed a lien on her house. She passed away 8 months later. The state then filed an estate recovery claim for another $140,000 in care expenses. Her daughter received notice that the house she grew up in would be sold by court order. There is a strategy some attorneys use when time is short. They call it the half-a-loaf strategy. The idea is that if you or your spouse already needs care, you transfer half of your remaining assets and use the other half to pay during the penalty period triggered by the gift. It preserves something. It is better than losing everything, but it requires precise timing. It requires an attorney who focuses on this area, and it must be done before the Medicaid application is submitted, not after. Once you apply, the strategy no longer works. The seniors who lose everything are usually not the ones who prepared. They are the ones who were never told preparation was possible. They sat in a hospital room, signed a power of attorney, and began writing checks to a nursing home with no idea that one conversation with the right attorney 2 years earlier could have protected the house, the savings, and the inheritance. Now, I told you at the beginning that there is one document many estate attorneys will not mention unless you request it. Here is the name. It is called a Medicaid Asset Protection Trust. In 5 states, including Florida, Texas, Michigan, West Virginia, and Vermont, there is also a tool called a ladybird deed, which accomplishes part of the same objective for the home. A Medicaid Asset Protection Trust is an irrevocable trust. You transfer your home, savings, and investments into the trust. Technically, you no longer own them. The trust does. But you may still live in the house. You may still receive income generated by the investments. You simply cannot take the assets back once the trust has existed for 5 years. After 5 years, those assets are no longer counted by Medicaid. The look-back cannot reach them. The estate recovery program cannot reach them. The house is secured. The savings are secured. Everything inside the trust passes directly to your heirs without probate, without estate recovery, and without state interference. Most attorneys do not raise this option for a simple reason. A Medicaid asset protection trust costs between $4,000 and $12,000 to establish properly. A basic will costs around $200. A senior asks for a will. The attorney prepares a will. And the conversation about long-term care planning never takes place. Therefore, you must arrive already knowing the correct term. You must say Medicaid Asset Protection Trust clearly. You must ask if you qualify. And you must do it at least 60 months before care is needed, because the 5-year clock does not begin until the trust is funded. Here is what to do this week. First, gather every bank statement from the past 60 months and identify any transfer over $500 to a family member. Make a list. You need to understand your exposure before speaking with anyone. Second, locate an attorney certified specifically in elder law. The credential is CELA, Certified Elder Law Attorney. A general estate planner is not enough. You need someone whose practice centers on Medicaid planning. Third, ask that attorney directly about a Medicaid Asset Protection Trust. And if you live in Florida, Texas, Michigan, West Virginia, or Vermont, also ask about a ladybird deed for your home. Fourth, fund the trust as soon as possible, because every day you delay adds another day to the end of your 5-year clock. Fifth, share this information with every adult child in your family, because this rule does not only impact you, it affects everything you plan to leave behind. The 5-year clock begins the day the trust is funded, not the day you decide to plan, not the day you contact a lawyer, but the day the assets actually transfer. Therefore, the most expensive day of your life is the day after you should have started.